Good evening, chat. Why am I so far? Yeah, so far away there. So far away there. Anyways, good evening, chat. Hello. Hope you guys are all doing well. Um, we're gonna get started tonight. This is gonna be kind of short, but it's gonna be funny. It's gonna be interactive. We finally have updates. You guys keep asking me, what's going on with Fuddbusters? What's going on with Fuddbusters? Said Cody Wilson. Well, we have some updates because as of today, like Friday the 13th, a bunch of shit dropped. And we've got some funny things that have happened, and yeah, like literally, as the title indicates, somebody spit on somebody. We're gonna get to that. I sound different, like I ate a wind sandwich. Well, I mean, all I can say is this is really bad for Cody, and it's not my fault. Oh my god. All right, guys. So we're gonna get here in a second. Debbie says, I don't know. Oh, what are you guys talking about? Is Matt coming on? No, I think Matt's in the middle of doing shit tonight, so I don't want to pester him. Because I was looking for updates and I saw like his Discord was going crazy, so I was like, oh wow, there are updates, and they're pretty good updates. They're pretty good updates, so we're gonna do that. But no, sorry, Rocco. No, I don't believe tonight Matt is coming on. Certainly, if he's out there, Matt, if you're watching, you want to come on, by all means, you're welcome to. But I don't want to impose. I didn't try to schedule it ahead of time. Didn't do that. So I wouldn't impose. I don't impose on people like that. I don't think that's fair. I think that's a little awkward. So yeah, that's how it works. I don't think that's it's not how we roll. It's not how we roll. So and the sagas that we were looking for. Hold on, chat. Let me see. What am I looking for? Oh, that's why, because I misspelled it. I couldn't find it earlier. So we have some updates to a couple different things, and this also responds to something we covered last night. So it's going to be kind of like a little bit of catching things up on all of the happenings with the busting of Fuds. If you guys remember, and we'll start off with last night just to kind of catch things up. Last night we talked about Control Pew, Fuddbusters, and Ivan all getting named in a complaint by the state of California and the city of San Francisco. And Torgo's saying PSA, AREX 01 pistols for cheap on Atlantic Firearms, $400 for a SIG 226. Yeah, that's correct. Yeah, the AREX pistols, they're basically SIG 226 copies, are better than the 226 copies. Every time I see him on streams, it's random. Well, yeah. Das Boot says, can I congratulate Chad on the tower? I will. Give me 1 second here. Somebody just told me to check Twitter. We'll end on that. Spud Gun. We'll end on that. But Spud Gun for £2 sterling. The King Sterling. He says, check Twitter before you start. Well, I just checked it. And yeah, we will do that at the end of the night here. Also, does this finally fucking work? Nope. I think my camera might be broken. Desk mode is not working, chat. I was fighting with that earlier. Tilt the device forward and try again. Yeah, it's not working. Well, that's no good. That's no good. And then also tonight, we got Debbie O for 5 subs. Thank you, Debbie. Hope you're doing well. Hope you're doing well. We get a woo for that. Yes, we will. Real quick. Hey, Clyde. Come here, bud. Oh, I see Bon. Hi, Bon Bon. Hi, Clyde. Come here, buddy. Come here. Come here. Clyde, hey. Clyde. Clyde, come here. Hey. Come here, Clyde. What are you doing? Come on. He's like, no, I want to go hang out with Bon Bon. So he's like, All right. He's like, what do you want, fat man? But thank you, Debbio. I guess we're not getting Clyde right now. We will in a minute, I bet. Your tactical Timmy edition SIG might not function, but at least it looks cool. Well, there you go. Yes. With the finest of the MIM parts made out of India. Yes. Nice haircut. Thank you. Yes. We got the hair did today. Oh, they did a good job. They did a good job. Not too many itchies afterwards. Offer treats. Yeah. You don't want to make him. He should come because he wants me. Drummer says the O&A forums want you to give a Pat Tomlinson update. Really? Okay. I mean, yeah, that's something I do need to work on. Yeah, gosh. How about assuming Russell Greer doesn't do a mass shooting next weekend? Friday, we're Pat posting. We're Pat posting next Friday. We're marking it down right now, chat. Marking it down. Pat posting next Friday. Okay. Yeah, I had to pay my state bar today. They're like, it's only $500. It's like, fucking A. I'm like, oh, free CLEs, I guess, but it's like, Jesus. All right. So 2/20. Patrick Tomlinson. We got to mark down, chat. It's happening. It's overdue. It's overdue, stalker children. We're all going to prison. It's been too long. It's been too long. The parts are made entirely out of Indians. Oh. Yes, we'll be making special pepperoni. Is Patrick Tomlinson in the Epstein files? Ooh, actually, we should let's check right now. Hold on. Well, let's check this. Epstein files. Epstein library. The library. Let's try this. I am not a robot. Thank you. All right. Are you 18 years of age or older? What happens if you say no? No. Access denied. So thank you for verifying your age. Okay. All right. Search full Epstein library. Tomlinson. Let's just start with that. Hey, it's how you spell Patrick's name, isn't it? Patrick Tomlinson. Yeah, Tomlinson. Yep, that's it. All right, let's try this and see what happens. Oh, LaDainian Tomlinson. Okay, so there's Tomlinsons here. Let's we'll refine it. Patrick Tomlinson. Oh. Well, we can always try pepperoni. We'll try pepperoni. Let's see if this gets anything. A lot of talk about pepperoni, though. A lot of talk about pepperoni. Oh, no. Oh, no, chat. Search stalker child. No. No, I guess nothing. Yes, he got redacted out of the files. Look, we got to try Milwaukee now, Malcolm says. We'll try Milwaukee. There's a U missing there, I think. MIL, no. WAUKEE. I think it's how you spell it. I'm on the wrong screen. I'm on my StreamYard stream and I'm clicking on the Epstein thing and it won't work. And I'm like, what the hell? Like a fucking tard. All right, let's try this. MILWAUKEE. Milwaukee. Ooh, he's elusive, chat. They got to it in time. Oh. Well, yes, Jean-Francois JF is in there, and Jeffrey Epstein yells at him for sucking at his job. So yeah, imagine you're getting bitched out by Jeffrey Epstein in the Epstein files. That's great. So, do I have a master list of shit I got to cover? I have had it before and it came down, but I need to work on another one. So, I need to work on another one. I Hate Yankees says, any plans to cover the Cali lawsuit against the catalog? Talked about that last night. Talked about it last night, and we will cover it more as it unfolds. And tonight we are going to, real quick, Yellow Flash Productions. How you doing, man? Hail. That's right, chat. Victorious in the struggle of Comicsgate. Taking care of it. Did I get a new camera? Yeah, we've had this for about a year now. New camera, yeah. It's looking good. Anyways, hope you're doing well, Flash. Friend of the channel, chat. Friend of the show. Definitely not a friend of EVS or Vito. It's also Hail War campaign out there. So, yes. I know Flash is here. I know. We got some celebrities tonight, chat. But let's get started. Let's get started with the lawsuits. This was one that actually has happened in the meantime. In response to what the state of California has done to Control Pew and Fuddbusters in the gang, well, they went back on a war foot here. They went back on the war foot. So what do we see here? Well, Control Pew, guys, remember, if you need stuff, you need some good merchandise out there. And also, guys, remember, Control Pew, the catalog, Fuddbusters, MAF Corporation, show them some love. Don't forget about Ivan. But show those guys some love out there. They definitely could use it. Remember, chat, you go to MAF Corporation, MAF-arms.com. Use the promo code POTCRIM, 10% off your order. 10% off your order. So what do you see here? Well, it's, Control Pew and Alex suing David Chu in his capacity as San Francisco city attorney, meaning he is the city solicitor. He is the attorney for the city of San Francisco. And also Rob Bonta as the attorney general of the state of California. So they're going after everybody here. And what are they doing? Well, this is a civil rights action under 14 U.S.C. 1983. Going right fucking back at them, chat. Remember, they are the government, so you can do this. Deprivation of rights under the color of law. And they want declaratory and injunctive relief to prevent the extraterritorial application of California civil codes on protected speech of people who are wholly in Florida. Now, they point out that the plaintiffs are Florida residents who publish and link to written guides, and they do all of this on the internet. And they say the defendants have announced and initiated a civil enforcement campaign that targets Florida-based speech and threatens civil and criminal penalties based on Florida's effort to regulate and suppress speech occurring in Florida merely because it may be accessible in California. This is what you got to argue. They're going for the big issues here, chat. They're going for the big-ass issues here. Oh my gosh, some of you guys are yeah, quarter days crashed out. Yeah, I saw some of that and heard some of that. Yeah. Got, fucking felting himself against D-Day Cobra and the gang. So but let's keep going, chat. We're gonna keep going. Yeah, friend of the show. Thank you, Wonder Bread. I don't know how many more days you're Wonder Bread, but you're still Wonder Bread. Yep, visit Yellow Flash, guys. Guys, he's always on Saturday nights, 10:30-ish. Certainly, he's probably going to be dabbing on fucking. He's going to be dabbing on Comicsgate and the Kangs of Comicsgate tomorrow night. So, join him for a celebratory dab. It's what he's going to get. You're like, I didn't know the fat man was flexible enough to dab. I am. But let's keep going here. Let's keep going. And they say the plaintiffs have been forced to self-censor and to cease registering copyrights for his works as a result. Remember, these copyrights are getting registered in the Library of Congress and through the Copyright Office. And they talk about jurisdiction here. And they point out this action arises under the Constitution and laws of the United States. There's also subject matter jurisdiction here because it's a federal issue in 1983. We also have First Amendment considerations. There's a lot of reasons why this is here. This court can grant declaratory relief, injunction relief. And they say jurisdiction is proper because the defendants have purposely directed an enforcement campaign at a Florida resident in Florida-based publication activity by filing a civil complaint that names them. And, for Floridian speech and links published on the internet. And then 2, publicly announcing the action and characterizing the Florida publication activity as unlawful. And 3, causing and intending to cause the brunt of the constitutional injury, chilled speech and self-censorship to be felt in La Floride. They point out venues proper because, it's where these guys, it's where Control Pew and Alec live. They live down in the Orlando area. They point out that Control Pew is a Florida LLC. They talk about Alec, and he's a natural person domiciled in Orlando. Rob Bonta is the Attorney General of the state of Florida and is sued in his official capacity for, declaratory injunctive relief under Ex Parte Young. And that is a case that goes all the way back, Chad, as 1908. And this goes back to stopping the government from doing something when they're getting involved like this. And it allows, this is the case that established federal courts for injunctions against officials in state action. When that state action is contrary to the Constitution. That's where this starts. And it's ultimately started out with, once again, as a shocker, in the state of Minnesota. Minnesota started fucking with the railroads. And they started declaring how the railroads start charging fines and start charging rates and how things would be done if you run a railroad through Minnesota. You can't do that. That's the Interstate Commerce Clause. There are federal regulations on the rails already. And the Supreme Court said, yep, we can enjoin state action in federal court. And I point out David Chiu, or Chayu, Chia, is the city attorney for the city and county of San Francisco. Remember, the city and the county are one and the same. They operate, well, anyways, moving on. Plaintiffs operate and maintain the Florida-based website Control Pew, 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 with written guides, photos, and digital files, including 3D models that are expressive works and technical instructions. It's all free speech, chat. All free speech. And KLF is, yes, lots of trains. Lots of trains coming through Minnesota. Be nice out there, chat. Be nice. Control Pew's website links to a third-party hosting platform, Odyssey, where, along with the catalog, all the shit is available. The speech is created and posted in Florida and is not directed at any particular site. They don't specifically target California users and do not direct advertising towards California and do not maintain offices in California. Plaintiffs do not travel to California and have no intention of ever doing so. I love this part. Plaintiff Holiday has not been to California since 2008 and specifically desires never to set foot there again. I mean, to be fair, I don't think anybody is really happy that they've had to deal with Florida or been in Florida or they currently live in Florida. I know some of you guys do live in Florida, and I'm sure you're like, I wish I was somewhere else. Oh. So they point out that there's a civil enforcement action here. And the civil enforcement action that California did is the people of the state of California versus the Gatalog Foundation et al. Seeking the permanent injunctions. And the biggest thing here is the civil penalties. And then they want to shut it down. And they point out that both Alec and Control Pew are named as defendants in that action. So they point out the complaint alleges that plaintiffs are unlawfully distributing and promoting downloading of downloadable digital code and instructions. And it seeks to suppress speech by court order and monetary penalties of up to $7.8 million. That's a lot, chat. That's a lot more than $6 million. That's a lot more than $6 million. Debbie says, no, those of us in Florida. Did I say Florida? I thought I meant meant California, not Florida. Sorry, chat. Sorry. Yes. California. Katie says, Ohio, where dreams die like the steel industry. You know what? I don't have to worry about people from California coming to Ohio. So, booyah. Booyah. No one comes here. That's a good thing. Only the dregs. So they point out that, once again, they go through here and that it's illegal to knowingly distribute computer code for 3D printing a firearm, precursor parts, receivers, firearm-related product, or a prohibited firearm accessory. And they point out the California complaint underscores the criminal law implications of the defendant's threatened enforcement because they cite California Penal Code in the footnotes, including footnotes 3 and 16. They fear that the civil enforcement actions are designed to drag them into a foreign jurisdiction where he may be subject to arrest in California for his Florida conduct, which is entirely lawful. Yes, because eventually if he has to show up, they're worried they're going to get arrested. And they say this has all been amplified. You know, the accusations have been amplified through a public press release. They reinforce plaintiffs' reasonable fear that defendants will use California coercive process to punish or suppress their speech. And the defendants announced the action through a press release dated February 6th, describing the lawsuit as a landmark effort. You know, like a landmark would be the San Andreas Fault cutting loose, but, you know, I guess this is a landmark effort in a way. So the filing of public statements have forced plaintiffs to self-censor. In particular, Holiday has refrained from publishing additional works and has paused planned publication activity on and through plaintiff's website for fear California will seek further civil and criminal penalties or injunctive relief. And it says plaintiff has registered many of the guides, photographs, models, and instructional materials he owns with the U.S. Copyright Office. And plaintiff fears because the deposit copies of such works could be obtained by a California resident from the Library of Congress, which is where they go, or the Copyright Office itself. And that's true. Once that stuff is there, you can request it. You know, but they fear they will be unable to register any additional copyrights with the Copyright Office. As a result, they've been forced to cease registering works. And because he fears he's unable to register his works, he loses out on his effective registration dates for the relevant works with each passing day. And because they lose the benefit of registration, plaintiff has been forced to elect to not publish additional works. Because remember, if they're not registered, it makes it harder for him to enforce copyright on parties. Especially fucking chode munchers like Cody Wilson and his little homo brigade. So it's always Seattle is the new Cleveland. That's rough. That's rough, Johan. That's really rough. And then moving on here, they say he's unable to register his works and he's unable to force a copyright. He's unable to force the copyrights because doing so would involve filing exhibits which would be available through Pacer to Californians. And that's the problem too. So if he tries to sue someone, guess what, chat? You can go on Pacer or Court Listener, and guess what you can do? You can start downloading all the documents. So like this one, Fuddbusters versus Cody. Look, you could grab all the documents off here. Now you're helping break the law. Yeah, these, you know, how do you comply at this point? How do you comply at this point? So, yes, JLR, I saw the au pair was sentenced today. Yes. Yes. He wishes to attach examples of some of his works as exhibits to this complaint, but he can't, as they would subject him to further harm from the defendants. Yes. I'm filing a court document, but it's going to be used against me. It says the defendants have not served Alice with process in the California action of this filing of this complaint. Nevertheless, the California complaint, the press release, and the stated posture create a credible and immediate threat of enforcement sufficient to chill free speech and establish an Article 3 case or controversy. Yes, because they might say, well, you haven't been served yet, so there is no risk. Well, it's actually not true because the government has said we're going to fucking go after these guys. So, no, they've established that burden. But that is what the state of California would try to argue. You know, they don't want to, this action does not seek to enjoin, stay, or interfere with proceedings in California state courts. They seek only declaratory and injunctive relief, preventing them from applying California code to things undertaken wholly in Florida. They point out that all the files, guides, photographs, and materials are protected by the First Amendment. And the courts have recognized that technical information and computer source code are speech for First Amendment purposes. And that's true. Guys, remember, a very long time ago, there was an encryption program called PGP, Pretty Good Privacy. And the guy who made it, it was actually a pretty advanced thing at the time. The government tried to stop him by saying what he had made was, the encryption program was a munition. And because it was classified as a munition, he couldn't take it out of the country without government permission. So he had to go to and fight for it to get his stuff declared as, it's just computer source code, and he had to have the right to do what he wanted. So yes, source code at times, it should generally be first. And I talk about the first claims, the First Amendment for prior restraint. Remember, courts don't like doing prior restraints, but this court's done it. They've silenced him. They've silenced him by doing this. It's operating as a prior restraint. So they talk about acting under the color of state law, have initiated and threatened to enforce California civil codes, which suppress and penalize plaintiffs' protected speech. And they say, as applied to plaintiffs' Florida-based speech, the challenge enforcement functions as an unconstitutional prior restraint and content-based restriction. Yes, it's solely because he's selling the content and the content is being made. It's not, well, how do we know that? Because if he was making 3D printed plans to make bird feeders, nobody would give a shit. But because it's firearm related, it's solely about the content. It's solely about the content. And they point out that it's not narrowly tailored to any compelling governmental interest, which is the standard for, a content-based restriction. And it has caused plaintiffs ongoing and irreparable injury through forcing self-censorship and preventing registration. And they want declaratory and injunctive relief. They also talk about a 14th Amendment due process. So they go through here and they point out the due process clause limits a state's authority to impose its law on persons with insufficient contacts to the state. And that's a big thing here. Insufficient contacts to the state and or to punish or enjoin conduct that wholly occurs outside the state's borders. Very true. Once again, the plaintiffs have Florida-based speech. And they point out that the applying California law here deprives the plaintiffs of fair notice and invites arbitrary enforcement because it conditions civil liability on the downstream acts of third parties and on the mere accessibility of speech in California. Yeah, once again, they're not being sued because they did something or gave something or directed something in California. It's just a website where people can retrieve information. Well, people from California can use it, so therefore they've broken California law, which once again is absolutely ridiculous. Absolutely ridiculous. Let's see here. By the way, I hate Yankees. I just want to say thank you. But yes, we are going to be working on that as more happens there. As more happens. Oh, sorry. Why did this go back? I hate it when they do that. But anyways, they are going through the 14th Amendment. They're doing the Dormant Commerce Clause as an extraterritorial regulation against both the AG and the city attorney. And this one here was against Bonta and Chu. Or is it Chayu? Chiu! Ah! Wata! That's all I know. Now, they point out that a Florida-based publication and linking on the internet using the California civil codes, they operate as extraterritorial regulation by controlling conduct and speech occurring wholly outside the jurisdiction of California, which is important. You're being hauled in or threatened to be hauled into a state where you have never done anything or directed anything or been doing anything at all. Doing anything at all. And they say an actual controversy exists between the plaintiffs and defendants concerning the constitutionality of the threatened enforcement as applied to Florida-based speech, and plaintiffs are entitled to a declaration of their rights and defense obligations. Count 4, the 1983, because it's a Second Amendment violation. And they point out publications and technical instructions relate to the design of lawful manufacture of arms and armed components to facilitate the exercise of plaintiffs and others' right to keep and bear arms. Kind of important. Kind of important there. And they say by seeking to suppress and penalize the Florida-based publications, the defendants burning conduct protected by the Second Amendment. Yeah, I can see it. Once again, they are entitled to a declaratory judgment. They want to stop this from happening. Signed, Matthew LaRosiere. That's right, guys. Fuddbusters himself. Get a hold of him. Get it done. Anyways, that's where they are right there. I know Ivan and Matt are thinking about their own 1982 stuff, but time will tell. They'll move and they'll do whatever legal strategies they think are correct. Ivan's legal strategy probably involve a lot of spinning as a rat. So good luck to him on that. Now, what do we need to get to here? So if we go back, and we have to go back in time, chat. We have to go back in time. Just like Trump says, you have to go back. This is Fuddbusters versus Cody Wilson. And if you guys don't remember who Cody Wilson is, I know they're going to cringe when I say it like this, but it's an easy way to explain it. Cody was like really the first big prominent member of the 3D printed firearms community. Granted, he wasn't like the biggest, like the smartest guy or the most creative guy and was a bit of a chode muncher all that time. Yes. But when you think of 3D printed guns, if you can remember that far back, Cody Wilson was involved. Cody Wilson has also had a couple runs with the law with underage girls. So Cody's got his own problems going on. Cody Wilson is also widely suspected of being a Fed. But what has Cody done? Well, Cody, as a ridiculous uber libertarian, doesn't believe in property rights, really, because at the end of the day, they think the trademarks and patents are all bullshit, but it's like people should be allowed to have intellectual property, shouldn't they? So anyways, what has Cody done? Well, Cody took all the files off the catalog, put them on his website, and then charged people money for them, which is something Matt never did, and did everything he could there. Yes, he did it at DefCAD. And Johan is right. Yes, it's also known as FedCAD. Yes. But known as DefCAD, that is where you could find it all. That is where they all went. They went to DefCAD, and Cody charged for him. And Matt tried to get him to stop, and Cody's like, neener. I'm going to do whatever the fuck I want. You're like, all right. So Matt sued him for copyright infringement in federal court because that's where you go. This case got filed September 6, 2024. Last updated February 13th, 7:26 p.m. Last date of last known filing, February 13th. This has drug on for a while. Cody initially had hired David Gingras, the lolcow attorney from the what is her name? Laura Owens trial. If you guys know the Laura Owens trial, that is where this comes from. And from here, things have kind of like just really fucking crashed and burned and like drug on forever. And I know you guys kept asking me, are things happening? And I'm like, no, it's just a lot of spurging going back and forth. Well, today, capped off a week of a 2.5-day hearing, or his 2-day hearing, I'm not really sure, between the Rat Man, Fuddbusters, and everybody, and Cody Wilson were all there. And they've had a couple days of everything going on. And the court has issued some orders. And I don't really want to go through all the things because I wasn't aware of all the things. I just learned about them, over yesterday and today. So we've got an entire thing here to deal with. Yes, the underage girls don't help with the Fed allegations either. No, but it's like him and Destiny could be friends. Now, Midnight Exile says, I do think he was entrapped. I don't think he was hard to entrap. Well, if you're not hard to entrap, sometimes maybe you need to suffer for your own stupidity. But he had 2 times the same problem arise. Like, it's not like it's just one time and it never ever happened again. Now, what happened here? Well, there's a bunch of filings that happened. And guys, if you weren't aware, in this case now, the court itself is up to filing number 214. So half as many things as in the Russell Greer case. And it's only been around for a fraction of the time. But it is it's moving along. Now, what had happened, a couple different things have been filed. There were some discovery issues that were trying to get sorted out. And today, Cody and his attorneys, they filed a motion for sanctions with a bunch of exhibits. Like, look at how many exhibits they filed. 1. They literally filed like 78 fucking exhibits. It's a lot of fucking exhibits. A lot of fucking exhibits. Don't goon. Well, that's always good advice. But look at all the shit they filed here. We're not going to read. I ain't reading all this. So I ain't reading all this. But what do we know that happened here? Well, like I said, guys, it's going to be a little short here, but we're going to take care of this. Yes. Mousy Mallard says, yes, away down south in the land of the traders, rattlesnakes and alligators. Oh, yes. Rabbit Stick says, could a Cali resident travel to another state, download it, bring it back to Cali? No. You would then be in possession of it, so no, I would not. That would not be a good idea. I would not recommend you do that. And if you're still wanting to do it, talk to a Florida attorney. But I would not recommend you jerk around on this because if it, do you really want to get involved like that? No, let someone else be the crash test dummy. Just let other people do it. So what did we see here? Well, there's a couple notices of filings. And this is the thing defense distributed. And Cody and all the goobers and the dipshits put together. They put together a attached motion in support of a Rule 37 motion for spoliation. And you're like, okay, well, what got spoliated? Well, to be fair, they don't really know. But they also want to appoint a special master, which they already lost on. But they point out that they filed a motion for spoliation on September 19th. Which included a request for an evidentiary hearing. The court granted the request and set a hearing for February 11th. In accordance with that, the defendant timely filed its witness and exhibit list. And they point out that the evidentiary hearing was canceled. And a lot of that's because Cody and his attorneys were not fucking prepared at all. Talked with Ivan and talked with the busted Fudd man. And he indicated where things were. And they point out that the defendant has a burden of first that the missing evidence existed at one time, and second, the alleged spoliator had a duty to preserve that evidence, and third, there's 3 parts, that the evidence was crucial to the movement and being able to prove the prima facie case or defense. And they claim they were prepared to meet their burden and remains prepared to do so should the court elect to reset the hearing. That's not what I heard. I heard you guys didn't have all your shit together, but hey, what do I know? What do I know? They point out in the interim, the defendant files exhibits it anticipates in introducing at the hearing for completeness. Fucking little 77 of them. 77 of them. Holy shit. This is insane. Again, I meant Florida. I meant California, not Florida. Do I keep saying it, or are you guys not understanding me? I mean, because like I feel like I have to bring it up, chat. Like it's not that I'm wrong. It's not that I'm wrong.
Always blame chat. When Sean doesn't share the screen, your fault. When you hate the Jannies, you're the Janny.
That's right, chat. I don't necessarily co-sign on the Janny part, but when I'm not the one who's wrong. I'm not the one who's wrong. I keep saying it. I don't know. I don't think you said that. Sand is an exfoliant. Yes. I beeped. Oh, you guys didn't know that? Yeah, I have a I have a bleeper button that comes on the thing. Although, yes, it's me backing up. No, I keep confusing Florida and California. Well. Oh, the smoke detector needs changed. Oh. Now, I spoke to Ivan about a lot of what was going on here, and there were a lot of issues they were trying to bring up and have documents introduced and authenticated that weren't original, that weren't the proper ones, that they weren't signed by the party they were asking to. Oh, I'm doing Morse? Yeah, hold on. I don't know if there's anything. I was like, it's a numbers. I'm worried I just did that and like activated a fucking number station somewhere. That's not good. But anyways, the exhibit attached are copies provided the court as official and bench copies. The copies were provided to plaintiff's counsel. From what I understand, not exactly. From what I've heard. Yes, I made slurs in Morse code. That would be. They also point out Exhibit 21 provided the court opposing counsel was an unredacted copy of the Firearms Development Employment Agreement purportedly executed by Matt and Ivan. Okay. Key that mic on VHF 17. No, I'm not doing that. I have my Baofeng. It could go on the Noah bands. That would be funny to broadcast on those. They say the redacted form plaintiff filed has been included here. They point out the defendant acknowledges that several of the documents are already on the document, but are nevertheless refiled as they were included on the exhibit list based on the court's directive that it would not allow admission of any exhibit not identified in accordance with his order. Yes. And one of the things they hadn't done yet is provided the defense with everything. Defense had asked for everything and they hadn't gotten everything yet. So just a wee little bit of a problem, chat. Just a wee little bit of a problemo. And this is Cody's thing here. But now we move on to what happened today. After this had happened, there have been a bunch of problems. There have been a bunch of fucking problems at the end of the day today. When I told you guys it's going to be short, I mean, it's kind of short. It's going to be kind of short, but it's going to be sweet, short, and sweet. And now here is when I'm probably going to say the wrong thing and probably get corrected for it. Anyways, this came out today, 12/13/26. Matt LaRosiere versus Cody Rutledge Wilson. Dildo CAD and Dildo Distributed. And then Scouring Dildos, LLC. So what happened? Well, this is the interesting part, chat. Cody, in his initial answer to the court, admitted to removing the copyright information and the copyright notices and warnings from the files they submitted and they put up on their website to sell. That they admitted to doing it and they made it clear that they did it. Well, that's an admission you know, in a copyright lawsuit, that's a very, 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 very bad thing. So what did they want to do? They came in and they filed an amended motion for leave to amend their answer in affirmative defenses. They also want to add a bunch of affirmative defenses. Now, why is this important? Well, remember, after you get served, you have 21 days to respond. And if you don't respond, you're in default. Okay. Well, you also don't get the time to amend your answer, especially now we're over like a year and a half in from that answer you filed. Well, you need a leave from the court or the opposing party can agree. Although if you're this deep into a lawsuit and you've messed up, the opposing party's probably not going to cut you a deal. You're probably going to be on your own, and you're going to have to deal with it. You're going to have to suffer. So... So anyway, they wanted to fix that because if they leave that in, they've now admitted to doing stuff and taking affirmative steps and knowing that it's copywritten. So ultimately, Matt said, no, I'm not allowing you to do that. The court addressed all this at a motion hearing held in February. So this is really good here. This is really good. Counsel for Matt appeared at the hearing, as did counsel for Cody, Def Cat, and Defense Distributed. The counsel for defendant Scouring Dildos, Chad Flores, did not appear, and the court memorialized the rulings it made. It says, upon consideration and the reasons stated on the record, the defendant's motion to modify and get leave to amend is denied for lack of good cause and diligence. They didn't work hard enough at it. And it says, when presented with the motion to amend pleadings after a deadline, the court must determine whether the party seeking leave to amend has shown good cause to modify the scheduling order. And it says the standard cause, this good cause standard precludes modification unless the schedule cannot be met despite the diligence of the party seeking the extension. And they talk about a couple different cases here, and they say denying leave to amend answers to a certain affirmative defense is based on new evidence, which is what they're claiming. Oh, we have new evidence. And no, it's stuff they've already been provided. Where the evidence was available earlier, which is it was, the defendant waited 2 months after the depositions when the information was obtained to file, and there was a lack of diligence. They also point out and then another case here denying the motion to amend based on the assertion of new evidence where the defendant unduly delayed its seeking amendment. The defendant failed to provide justification to be allowed to completely reverse the previously admitted allegations. They point out that the defendant did not establish how the new evidence related to the proposed amendment. Now they talk about they go on through here as they explain here. The finding assertion of new evidence did not provide enough good cause to support amendment because the defendants had the information they claimed was new and because to expand the litigation would burden your opponent. Oh, did I beep too much or where did everybody go? Chat just died. Rabbit Stick says, stop that shit on earbud. Sorry. They say, as stated at the hearing, the objections period related to this order shall run from the date of this written order, meaning you can appeal it to someone else. That was done and ordered in Florida on February 13th, 2026. So get ready for this, chat, because there's going to be a lot to come here. There's going to be a lot to come. This is where things start. We aren't to the spit on that thing part, but we're going to be there very quickly. We're going to be there very quickly. Once again, it's Matt. Why is this not working? Ooh. Huh. Hold on, chat. That was weird. Let's try that again. Let's try this again. All right, there we go. There we go. All right, the beep, beep, beep. I'm feeling it. Yeah. Anyways, once again, this is Cody or Matt versus Cody. And here we go. It's out of ink. Yeah. Now, what happened? Well, Matt filed a motion to quash improper third-party subpoenas. And Cody was looking for stuff from Shopify, Etsy, and registered agents. And they responded in kind and said upon initial considerations here, the motion is denied in part and deferred in part. And they say, such that the court denies plaintiff's request to quash subpoenas for lack of standing, but they refer to the request for a protective order regarding their issuance, pending briefs on the parties on the whether subpoenas can seek information relevant to this case. And I don't know if they can. I don't think they can at this point. Yes, chat, you used up all the damn ink! They point out the parties submitted the briefing. The court addressed the matter at a hearing on February 10th. Counsel for plaintiff appeared, as did the counsel for everybody. Counsel for scouring dildos did not appear. This order memorializes the thangs made up at the hearing. They say upon discussion with the appearing counsel for the reasons stated on the record, they point out that, the motion is granted in part and denied in part in its remainder. It is ordered as follows. Now, Cody and his dildo brigade could serve subpoenas directly on Shopify, Etsy, and registered agents as set forth in the hearing upon 7 days' notice to the plaintiff. And a subpoena to Etsy shall be modified and limited as follows. The request shall ask only for all information sufficient to identify the person or entity and or formerly operating the e-commerce store under the name Duncan Manufacturing. Which, okay. So notice it's getting cut back pretty far. It's getting back pretty far. It's getting cut back pretty far here. So, so it just goes through a list here. It goes through a list of everything they want to do. And they point out what you can ask for, what you can't ask for. They're talking about the subpoena to registered agents. It's limited as follows. Hold on here, chat. No, that's not what I need here. We're gonna keep going. Am I wearing pants? No. I'm just rubbing my taint. I'm just rubbing my taint all over the chair. DDO says, funny. All right, guys. So the next thing here is, what is this? So there's some funny stuff here. There is some funny stuff. This is a big order coming out of the court. We're saving the best for last. That's the way it worked. But this right here gets us into some fun stuff. Once again, Matt versus Cody. This is still a copyright lawsuit. As Russell Greer said, copyright lawsuit. Yes, thank you, Russell. And you're like, your mom. But no, maybe him and Russell could work together. Maybe make a drooling gun. So they point out that Matt's short form motion to overrule meritless objections and compel complete responses to interrogatories and requests for production. They've asked for a lot of documents. And what's happened is, how much money does they'd ask Cody, how much money does DefCAD make? And he'd be like, well, I don't know. I'm not in charge of that. I don't know. That's somebody else's job. And it's like, you're on the motherfucking company. How do you not know? And all this kind of goofy shit has started here. All this goofy stuff has started. And it's like, why are you all shit being goofy? Like, you don't have to do it. Don't have to be stupid about it. And they point out here that there are responses to interrogatories and requests for productions, discovery demands. And it says the court held a hearing on February 10th. And it said counsel for plaintiff appeared at the hearing as a counsel for defendants Wilson, DefCAD, and Defense Distributed. And it says, once again, counsel for the scouring dildo. Do I have narcolepsy too? No, I didn't get any sleep last night. Did not appear, however. Sweet Tooth Fairy is doing a trying to get my attention. I don't know. This order memorializes all the rulings made at the hearing. So this is just the court kind of reviewing everything for us. And this has just happened this week. And they say a brief history is relevant to this motion. I mean, is it really? Is it really going to be brief? So they said after filing the motion, Cody Wilson and all the gang responded in opposition. 2 days later, and given the history of this case, the court issued an order requiring further conferral on the motion to take place in Orlando in the presence of a certified court reporter. Now, here's the issue. If you talk to Fuddbusters about this, and he said it, when these guys meet, it's a fucking disaster because Cody and Wilson's previous attorneys were liars and fucking morons. Well, he's got new attorneys now, and yeah, meeting with a court reporter, documenting the meeting is a safe way to handle stuff. Is it a grindy problem for them if you're living out of town? Yeah, but you know, you make your bed, you have to sleep in it. So they have to do it in the presence of a certified court reporter. The court further ordered the parties to file a joint status report after the conferral to include a recitation of the errors, what issues remain for jurisdiction by the court, you know, referencing, you know, anything, really, actually. You know, it's, you know, recitation of the conferral efforts, what issues remained for resolution by the court, and all these things here. And they point out that the position on these issues don't attach to court reporter's transcript of the meet and confer. I mean, you'd like to think they keep it short, but from what I understand, it's not exactly. So, something I need to talk to Fuddbusters about. I'd like to get a hold of those transcripts. I think we went over one of them. I don't recall. But yes, he said the ones here at SHOT Show are hilarious. Or not at SHOT. No, not a SHOT Show. What's the thing they just all did? It was a SHOT Show. Yeah. I don't know why I said that. Anyways. No, the things at their their fucking status conference, not SHOT Show. Why they call it that? All right. So they did timely file their joint status report. But as set forth therein, despite the 2-day conferral chat, and here's the problem. A 2-day conferral. My God, buddy. What are you guys doing? A 2-day conferral. A 2-day conferral. And a 441-page transcript. The parties were unable to resolve the majority of their disputes involving discovery, which notably includes hundreds of RFPs and interrogatories. And this is the judge being pissed off. The parties resolved 4 requests, to be exact. This is the judge being Ethan Ralph for COG. You know, if you want to know the truth about it. Well, the judge going... It's 441 pages, and they've only resolved 4 of their problems. If you'd like to be factually accurate, mate. That's a lot of talking. That is a lot of fucking talking. Oh, that's a lot of fucking... They only got 4 of them done out of the massive ton of them. Notice how many she talked about. Yes, I ain't reading all that, quoted the judge. Pretty much. She's like, I have to wrangle all of you tards myself, and she's not happy to do it. She's like, I got to put on my tard wrangling boots. And she's like, they don't fit anymore. My kids are all gone. And she says, with respect to specific interrogatories or RFPs are remain outstanding, the parties chose to group them into several categories with some side issues to include relevance and proportionality, temporal scope disputes, redefining the terms of copyright and works, definition of possession, custody, and control, defendant's production of unindexed files, which he just gave them just garbage, unsupported privilege and work product objections, and then the parties' inability to enter into an agreed electronically stored information protocol, which is normally what you do there. And it says, based on the joint status report of January 14th, The court set the matter for hearing on February 10th. And the order setting the hearing, the court made preliminary rulings on a few issues and ordered pre-hearing briefing from the parties, meaning they had to talk about what was going on here. And they said the court in that order overruled any objections raised by the defendants in response to discovery that were not addressed in the status report. Notice, if you don't bring up your objections timely, they get denied. It's not just on an appeal, chat. It's not just on an appeal. They didn't raise objections in their status report. Well, it's too late then. They also tried to make arguments like undue burden or that the documents were in the plaintiff's possession and could be found in public sources. That's not really an answer either. They sustained in part on defendants' objections on the basis of possession, custody, and control. And the court would apply the definitions of possession, custody, or control out of an 11th Circuit case. And the court was inclined to follow the rulings of another court with respect to information that Cody Wilson, sued solely in his individual capacity, will be required to produce. It sustained Cody's objections regarding the definition of the term copyright works, such as these terms are limited to the copyright works identified in the plaintiff's operative complaint. So, yes, the lawyers are the only ones winning right now. I mean, that's very true. That's very true, chat, how this works. But V2 says, are you wearing pants? No, I'm not. I own you. I can't do the build out voice. It says for $5, it says Alec Baldwin going to signing autographs. Should I get him to sign a gun, safety rule, or a revolver? If you could take like a toy gun to have him sign, that would be hilarious. But yeah, have him take like an NRA gun safety pamphlet and see if he'll sign it. And then it says the court further ordered the parties to brief the issues of alter ego, willfulness, temporal scope, financial discovery, attorney-client privilege, and work product, the status of any production, and the issue of the electronically stored information protocol. And it says, to the extent the defendants raised a privilege protection issue, the court ordered the defendants to serve on plaintiff a privilege log. And guys, a privilege log is a big deal. It's something we're going to go over here because I did see that in the Blake Lively lawsuit that's going on. Andy Signore from Popcorn Planet, he got subpoenaed for information and he tried to assert privilege and he fucked it all up. And we'll go through what a privilege log should be if you're trying to, assert privilege. But we'll point out some stuff here. They point out that the parties timely submitted their pre-hearing briefing. The parties also continue to confer, but resolve no further issues. And that is a very thing here. I've talked with Matt about this. Apparently, they are just fucking assholes. They are just assholes at this point. Oh. Robin Hood says temporal scope. Pretty sure ACOG doesn't sell those. No. No. Not yet. This is straight out of Greer's playbook. If they have it, it's a burden. If it's not fair. Kind of. I mean, it's lolcows do lolcow things. Lolcows run the same playbook. They said, subsequent to the order, plaintiff filed partial objections with the presiding district judge regarding the court's preliminary rulings. And it says, at the outset of the motion on February 10th, the court addressed to the parties the propriety of proceeding with the hearing in light of the outstanding objections. Plaintiff's counsel stated that those were done in an abundance of caution and to preserve the record. But in recognition, the preliminary rulings were non-final, meaning preliminary rulings could still be changed. Stated the hearing could proceed. Cody's counsel also said the same thing. As discussed with the parties, the rulings were preliminary in nature, meaning they could be fixed, and preliminary rulings will be subsumed by the final order to the extent they are not modified at the hearing. The court also told the party, yes, you have an objections period that covers a preliminary order in this order. So you get the chance to object to things. It's just you need time for it. So they go on, and the court addressed everything that's going on here. So, they once again talk about the categories of objections. Both parties voiced agreement to do it this way. In other words, the court addressed the outstanding discovery issues in the same manner the parties presented them. And this order sets forth what's going to happen here. So here's what's going on. And they say Matt's short form motion to overrule meritless objections and compel interrogatories is granted in part and denied in part. So here we go. As set forth at a hearing, any objections previously raised and not addressed have been waived and are overruled. Okay. So what happens? Alter ego issues. The court finds discovery as to whether Cody Wilson and the entities DefCAD, Defense Distributed, and Dioscuri are alter egos could be relevant in this case. And it is. It's true. Are they alter egos or are they independent entities? It says, however, outside of these parties, plaintiff has not established relevance at this time. Accordingly, it's ordered that the RFPs and interrogatories seeking discovery with alter egos are limited to the named defendants in this case, which are Cody, DefCAD, Defense Distributed, and Dildo Scouring. They talk about the definition of copyright works. So the court made its ruling here, and it says that because willfulness relates to the copyrights at issue, it's ordered that the definitions of copyright and works are defined and limited to the copyrights and works specifically identified in Matt's first amended complaint. They say financial records. The defendant's objections based on lack of control due to the records being in possession of a bookkeeper are overruled. And that's what Cody said. Like, all my financial records, the bookkeeper has them. I don't have them. The bookkeeper works for you. You are his client. You have control over them. So the court also finds insufficient the production of a summary chart created by Cody. So within 14 days, Cody shall produce to Matt and the gang individual tax returns for January 2021 to present. It's ordered by that same deadline that DefCAD, Defense Distributed shall each produce balance statements, income statements, and tax returns from 2021 to present. Because it could be relevant. It might lead to more discovery. And they talk about temporal scope. By Matt's concession, the RFPs, the requests for production, the discovery demands, and the interrogatories tied to the copyright works identified in the operative complaint, it's ordered those requests are limited to the time period of January 1st, 2022 to present. For all other interrogatories not directly related to copyrights and works, it's ordered that the temporal scope, meaning the scope of time we're looking into, will be limited to January 1st, 2021 to the present. So the temporal scope, like the time frame we're looking at, the time window from 2021 to today. That's it. And I talk about possession, custody, or control. And they say, as it relates to RFPs directed to Cody Wilson's defendants, the objections are sustained at this part. And it says, Matt conceded that the discovery seeking corporate documents related to the entities have been properly requested from the corporate defendants themselves. And those discovery requests were not yet ripe as of the time of this hearing. And they aren't. So this is denied right now with respect to the documents should be obtained from the defendant entities or other sources rather than Cody in his individual capacity. So they wanted to go to Cody, and then they're like, look, we're not there yet for now. They say, though, with respect to Cody's individual possession and control, however, with respect to RFPs issued to Cody, it's ordered within 14 days. Cody shall file amended responses to the following requests for production and produce responsive documents as follows. And it says, to the extent already not produced, he shall produce responsive documents going from January 1st, 2022 forward. And they point out here that, and they say, though, that Cody will produce the documents in the possession or custody control of defense distributed in DefCat. So basically he's acknowledging, yeah, I have control over him. They say, as agreed by defense counsel, Cody shall produce documents and communications relating to the payment of cryptocurrency or legal currency from any of the defendant entities to Cody from January 1st to present. Yes, because Cody claims he is an employee of these. This is Cody shall produce responsive documents to the extent that reference Bitcoin addresses and accounts that are Cody's personal or individual addresses or accounts. And they point out that Cody shall just produce documents that are in his control. Cody shall produce documents that are subject to the definition of copyright and works. They talk more about pursuant to counsel. Cody's also agreed to produce responsive documents from Defense Distributed in DefCAD. There's an affidavit of compliance. Cody will submit an affidavit fully executed under penalty of perjury and notarized, detailing the scope of his search for responsive documents, which shall demonstrate a reasonable and diligent search. Notice, they're saying you don't get to fuck around and phone it in, and include how and where he searched for responsive information. Cell phone, email, house, computer. Yeah, how you did it. Now, this is interesting here. Privilege in a work product. Pre-hearing, the defendants, were told if they maintain any privilege or work product assertions, they have to provide a privilege log to the plaintiff in the court. And that's because these courts all have standing orders on privilege logs. Like, it's entirely a thing. So what happened here? The defendant submitted a privilege log, but it does not comply, as is some other things, fails to identify the persons listed by job title or otherwise. And the descriptions are fatally vague. You can't just say, we talked about something. At the hearing, defense counsel had no cogent explanation for the failure. So, and here's the thing here. All attorney-client privilege and work product objections assertions, as it relates to communication between Cody Wilson and Garrett Wellman, and this is Cody Wilson was going to law school, but Cody never got through. I don't think Cody even got through law school, but he definitely did take the fucking bar. He's not a fucking attorney. And Garrett Wellman is Cody's field hand. You might call him a field Negro. But yes, he's like Samuel L. Jackson and Django. He lives up in the big house. He work up in the big house. Well, Massa Cody. But notice the court even pointed out, 2 non-attorneys. You are not a lawyer. You will never be a woman. They are overruled as waived for failure to comply with the court's pre-hearing order. Even if they had complied, there's no attorney-client privilege. There wouldn't be any other privilege there. It's just fucking like thrown out. It's thrown out. So they shall produce to Matt all these communications between Cody and Wallyman in unredacted format. As to the remainder of the communications listed in the privilege log, within 7 days, defendant shall produce to plaintiff a privilege log in full compliance with the standing order, which shows you how to do it. Yes, is it his hand jobber? Yes. Yes, and has chick, yes. Somebody needs to hold Cody's purse. He's the purse holder. And they point out that keeps going here, and they say, within 7 days of service of amending the logs, the parties shall conduct a substantive meet and confer to determine whether there are any outstanding privilege issues. Until then, this portion of the motion will be denied without prejudice for renewal within 14 days of the meet and confer if necessary. Meaning, it's denied without prejudice because I'm ordering it to happen. So it's kind of moot. But now that you get them, if it's all garbage, file your motion again. So Cody asserted privilege regarding Sarah Westman. But ultimately, he's saying there are no responsive documents relating to Miss Westman, which makes sense. And they say, to the extent that plaintiff claims defendants improperly served unindexed PDF files. It's funny when you say it like that, talking about Cody Wilson. It's like, you know what would really be like an unholy alliance is Cody Wilson and Vito fighting each other in the darkness. There'd be a lot of unindexed PDF files. It failed to specifically state which document production was responsive. The motion is denied because you failed to specifically state which productions were responsive. You have to state specifically what they didn't do. It said Matt provided no law and support, and the court finds the defendant's production chart sufficient given the volume of discovery plaintiff served. Like, oh, come on, Judge. No orphans. No orphans or widows. Control Enter. And they say this issue comes out of the parties' inability to agree on an ESI protocol and concerns Cody's production of Slack chat screenshots. So what does Cody have to do? Cody shall produce to the plaintiff and file with the court an affidavit signed under penalty of perjury and notarized. An affidavit separate and apart from the affidavit on reasonable search as set forth above, meaning he's got to do it for 2 under penalty of perjury. 2. A list of all nicknames, usernames, and topics relevant to the issues in this case as framed by the discovery request for the time periods of January 2022 to present. The terminology and words used to identify the works in the amended complaint. All search terms Cody used to describe Matt LaRosiere. Remember, they had all those pictures and all the shit that was drawn about Matt. I'm not going to start calling them things. The terminology user terms Wilson used to describe plaintiff and or John Ellick, also known as Ivan the Rat, the Spinning Rat. And then all names or terms used to describe the catalog. So within 14 days, the parties file a joint notice. Yeah. But notice, Cody is like, and upon submission of the affidavit and the parties' respective positions and custodians, the court will enter an electronically stored information protocol. And it says, to the extent not addressed in this order, Matt's stuff is denied in all other aspects and respects. And as stated at the hearing, there will be a objections period related to this. They point out here, though, the court says, for future discovery motions, unless the motions designated as time sensitive or an emergency, or obligations to do this, they have to schedule a meet and confer motion for 3 days. If the parties can't set up a meet and confer within that 3-day period, they may file the motion with the court noting the same. Pursuant to local rule, the movement has an obligation for 3 days thereafter to diligently attempt to compete the meet and confer, meaning, and by the 4th day, file a supplemental to the motion certifying conferral efforts. Meaning after 4 days, you have to come in and say, look, Judge, here's what I did. I called twice a day. I called first thing in the morning. I called again midday. I sent an email each day. They never responded. And let's say they happen to be in the same town. You can say, look, I even went by their office and knocked on their door. Here's me doing it. So parties are cautioned, and this is a Russell Greer thing. The purposeful evasion of a communication to meet and confer can result in a sanction. Yes. And this is the court just kind of like, look, the judge is like, I'll have to do this for you, you little fuckers. She's like, you can't do it. I'll do it. And then moving on here, chat, we are moving on to the pièce de résistance. As Philip Burnell, the warrior poet of Renton, Washington, might say, it's the penultimate. Well, actually, we were just on the penultimate. But this one is robust and tangy. This one is really good, chat. It's only 7 pages, but uh-oh. Some stuff happened. Stuff happened, and stuff happened, chat. As Ilhan Omar once said, was it her? Yeah, somebody did something. Somebody did something. Uh-oh. Okay, so once again, you have Fuddbusters versus Cody. Order. Before the court is Cody's motion for Rule 37 spoliation relief with the appointment of special master. Remember, Cody and the gang today filed this fucking spurg out motion of all the stuff that was spoliated and for sanctions under Rule 37. Like, look at what he filed. Like, bleh. And notice this happened today. And as he filed it, all this stuff happened. The judge even put together an order on top of it because as of the 10th and 11th, they had this meet and confer where the court sat down with them in the hearings to figure this all out. I'm glad you guys are having fun in chat. I'm glad you guys are having fun in chat. But we are now back onto this. We're now back onto this. And real quick, some guy with cancer. For $5. Thank you. Hope you're doing well, man. Keep up the fight. Keep up the fight, man. Hope you're hanging in there. Says, I'm a bit late. Did you watch the Murdaugh appeal hearing? No, we're going to do that tomorrow. We're also going to try to figure out how to get an Edric Faust soon. But we're definitely doing Murdaugh's stuff tomorrow afternoon. I don't know if we're going to do anything in the evening. We'll do tomorrow in the afternoon, probably like 2 o'clock or so, because it's like 3 hours long and I want to get it done. So we're going to do Murdaugh's appeal tomorrow. From the hearing, it strongly looks like he will get a new trial, which he should. I thought he got a bum rap and should have gotten a new trial. But once again, remember, guys, the appeal, appeals are for losers. You're already behind the curve trying to change it. But it sounds like they did a pretty good showing. So we'll see. But anyways, hope you're hanging in there, man. Hope you're hanging in there. And thank you for the super chat. And guys, thank you all for your support tonight. Also, chat froze. Am I still? No, I am still live. But I don't, when chat's not moving, I'm like, God, I sound like Phil. Like, the chat's not moving. There's nobody here. Is Cody using AI sloppa? No, Cody has a team of attorneys. So they say, upon consideration of the filings and exhibits attached, the court set the matter for an in-person evidentiary hearing on February 11th. In that order, which consisted of nearly 5 pages of instructions, the court directed the parties to file exhibit and witness list by date certain to appear at the hearing, with at least 3 copies of all exhibits, and cautioned the parties that any witness or exhibit not listed on the party's witness list would not be admitted into evidence, which is a big fucking problem. Yes, chat, this is the big thing here where you need to listen. This is the good stuff. Hi, Johnny. Yes. Oh, God. Here we go. Lamau. This order is great. Yes. Very much a Lamau indeed.
You are gay. LMAO.
LMAO. So, the court advised the FRE would apply, and failure to comply could result in sanctions. The court issued such a lengthy and detailed order due to the parties' inconsistent inability to confer and cooperate. However, the court did not direct the parties to exchange copies of all exhibits prior. And this is, remember I told you guys there were problems with the exhibits being switched around. Cody's team never provided the exhibits to Matt because they are dickheads. And they said, we don't have to. They also said you could find them online. But notice the court's like, believing the parties would at least work together on that front in order to ensure the omission of evidence in a relatively professional manner. As discussed below, the court was gravely mistaken. Yes, I thought you guys would not be fucking assholes. I guess I was wrong. Tully Pip says, that's because you have us hanging on your every word, mate, and governor. Yes. Factually accurate. Oh, yeah. Chat, it only gets worse from here. It's kind of like one of those, it's like those election night memes where it's like, do, 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 do. it's starting now. Where it's like that thing that's that meme song. It's like past lives. Do 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 do. It's just starting out very slow. Wait, I forget how it goes. But yes, it's like the past lives thing. It's like it's starting out real slow. Um, parties timely filed their witness list. And they did defense distributed timely filed its exhibit list, which had 79 exhibits. Plaintiff did not list any exhibits. Upon review, the court noticed that defense distributed had named Matt's attorney, Zach Zermay, as a potential witness. At the conclusion of the prior day's hearings, and the court says we had a lengthy discussion about why you all are fucking retards already. Sweet Tooth is 2.0 back yet? Yes, she is. I picked her up from the airport today, and oh my God, it's Cleveland Airport and the arrival area is a fucking mess. But thankfully, only one airplane a day really flies in, so it's not too bad. But the arrival area is basically completely destroyed from construction. So don't come to Cleveland. Be careful about it. So the court inquired about calling attorney Zermay and was informed by Cody's counsel the reason for listing him was solely to authenticate certain documents, specifically discovery requests and responses. Cody's counsel stated the parties had not been able to confer and reach an agreement as to the authenticity of these documents, several of which were signed by Zermay himself. And after discussion with the parties, court directed counsel to resolve the issue prior to the start of the hearing. Now, if you talking to Matt and Ivan, there were times where they said, authenticate this, and they're like, I didn't sign that. It's not my name. So there's a problem. So here we go. The court directed the parties to work together. The court explained to the parties that the first item at the start of the hearing would be discussing this. And the court's like, don't fuck around. I'm calling you first to discuss this issue. At the time, counsel for Cody notified the court of an issue. She was locked out of her office and unable to obtain the hearing exhibits. This happens. So the court continued hearing to 1 p.m., and the court does not find fault with this unexpected occurrence, nor should this order be read as any sort of sanction for this mishap. Shit happens, chat. What happened next is a different story. Matt, Ivan, I love you guys, but I'm sorry. This is great. Yes, and then it got worse. It's like, hold on. We got to do this. I got to find it. Hold on, chat. Oh, you son of a bitch. You're premiering an MP40 video on Fuddbusters, bastard. We got to do this, chat. Hold on. Oh no! It's getting worse, chat. Gotta be scared. It's gonna get worse, chat. All right, we're getting back to this. I hope you guys could hear that. Oh, when the court convened at 1 p.m. as promised, the court addressed the exhibits. After a brief discussion regarding the admission of a civil complaint recently filed in California, the court inquired about the authenticity issue and attorney Zermay. Unfortunately, the parties were still somehow unable to agree on the authenticity of several discovery documents. Again, many of which were signed by attorney Zermay. Notice, many. That means not all of them were. The court endeavored to reach a resolution with the parties, but their inability to communicate with each other in a productive manner rendered this an exercise in futility, which culminated in Cody's counsel admitting She had not provided a complete copy of her exhibits to Matt's counsel in advance of the hearing, such that they were arguing over issues that could have and should have been resolved well in advance of the hearing. Uh-oh. Uh-oh. Oh, no. Oh, no. Oh, no. This ain't good, chat. This ain't good at all. Uh-oh. Whoo. Whoo. The court strongly admonished the parties, which I don't think is fair because Matt and them pointed out you didn't give it to us. And after taking a short break, the court came to the inevitable conclusion the inability of counsel on both sides to reach an agreement. But how do you reach an agreement when one side won't comply? That's not fair. If Cody's team can't get their shit together, why is it Matt's fault? Like, how do you reach an agreement with somebody who's not in compliance? That's almost like if Cody's team pulled out a gun and said, we're going to kill somebody on your team, Matt. And Matt's like, I don't want you to do that. Is the court going to be like, wait, no, you have to let him kill one of the people on your team. Don't obstruct. It's like, come on, Judge. Come on. Yes. Yes, Spoonie. Yes. Break out the triangle. Yes. Yes, this is a whoa buddy moment. Yes. Ding, 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 ding. Retard alert. Oh, I wish we had our TardCon warning set up yet, but we're working on that, chat. Don't worry. We'll need this energy in Greer versus Moon. Well, we need, yes, we do. We need this energy in a lot of cases. As the court noted on the record, this pattern has been consistent since the inception of this case, resulting in a waste of judicial resources. The court thereafter canceled the fucking hearing. Oh. The court has taken pains to determine the appropriate course moving forward. As the court noted several times at the February 10th hearing, until February 6th, lead counsel for all defendants was attorney Charles Flores. As of February 6th, is now listed as additional counsel for Cody. This says this frustrating pattern was also discussed at length on February 10th. I'm sure it was. The current counsel for the defense distributed are attorneys Leah Leitner and attorney Amaris Gaivey. Did not first appear until October 2nd, 2025, and attorney Leitner did not take over until February 26th as lead counsel. However, the motions for spoliation sanctions authorized applying all exhibits were followed by attorney Flores when he's lead counsel. Yet, inexplicably, attorney Flores did not appear at the February 11th hearing, thus leaving these two attorneys holding the proverbial bag. The court recognizes this timeline, but does not excuse counsel from working with plaintiff's counsel on the basic issue of authenticity. Nor does it excuse Matt's attorney from his duty to confer and cooperate. How do you confer and cooperate when they don't have their shit together? How do you, like, once again, they're offering him bullshit. Give me the documents. No. How do you fucking comply? How do you fucking comply? Don't I have a cowboy? Yeah, but I gotta, do you think I gotta turn, like, get up and turn around? Like, that's calories, man. No. Richard Gruber, how you doing, sir? Says there's a new Steve MRE 1989. Yeah, he's been hitting it pretty hard lately. I saw the new Italian one, The Dinner. That actually looks like a pretty good one to watch. So. Oh. So anyways, given the history of this case and the events that transpired on February 11th, it's like, Mr. President, another sanction has hit the tower. The motion for spoliation has been denied without prejudice. Within 30 days of this order, defense distributed may file a renewed spoliation motion. The motion may not exceed 30 pages and must be supported by relevant legal authority. All declarations must comply Within 21 days, Matt shall file a response, not to exceed 30 pages. It must be supported by relevant legal authority, meaning they're getting really fucking mad. The judge is really fucking mad now. Like, don't just say it's not good. You better have fucking sources. Within 14 days of the filing, Cody could file a reply brief, no more than 10 pages. You can only address issues raised in the response and may not be used to address new arguments. You might say, wow, isn't this kind of normal? It goes, yes. But the judge is like, you little fuckers, I'm spelling it out for all of you. It's going, water, Helen, water. Judge probably went home and kicked her fucking dog after this, sadly. Within 14 days of the filing of any reply, the party shall file a joint statement of undisputed facts. Meaning, what do you agree upon? As a separate joint statement, meaning of disputed facts, meaning they're going to have a joint document of saying, here's what we disagree on, here's what we disagree on. The joint statements are not an opportunity for argument, but simply list by number a concise statement of each fact not agreed. Upon receipt of these filings, the court will take the motion under advisement for such proceedings as the court deems necessary and appropriate. Uh-oh, in chat, but wait, there's more. You see this there's a little footnote at the bottom. What's that about? The court has chosen this path rather than rescheduling the evidentiary hearing. Actually, we're going to hold on to it. I forgot. We're going to wait. Put a pin in that. Because the court canceled the evidentiary hearing and denying without prejudice the motion. Any rulings on that hearing on the admissibility of exhibits are vacated and withdrawn. In addition, earlier today, defense distributed filed a docket notice filing along with a copy of all 79 of its exhibits that it anticipated introducing. This is a problem here. They did not seek leave of court to make this filing. And in accordance with the court's ruling, this filing and all attachments are hereby stricken. The court is very fucking angry right now. Uh-oh. The clerk is directed to remove them from the docket. Oh boy. Now let's go back up here. Signed, judge. So there we go. Court has chosen this path rather than rescheduling the evidentiary hearing, in part due to the party's pattern of behavior, and in part due to the court's awareness of an incident that occurred outside the courthouse immediately after the cancellation of the hearing, which resulted in the involvement of the United States Marshal Service and the Orlando Police Department. Oh, chat. I mean, like an awareness of an incident outside the courthouse that required the involvement of the United States Marshal Service and the Orlando Police Department. So I know the answer to what happened, and it's been discussed openly now because the court's now aware of it. So outside the courthouse, remember, chat, who controls the courthouse? The United States Marshals. They control the federal courthouse. And then the Orlando Police Department. Why? Because it actually may have occurred off of federal property in the city of Orlando. There's no body cam necessarily. It's not a body cam issue, but there's security camera footage because, believe it or not, chat, federal buildings have great security cameras in downtown Orlando. There's probably other cameras that are available too. So there will be camera footage. So what happened? Well, as some talking occurred, as Matt and Cody's teams walked out, there was some talk of things. And at one point, Matt talked to Cody's, once again, field Negro, Garrett. And Matt was actually kind of nice about it. And, Garrett told Matt, basically have fun dealing with your shit in California, which really kind of leads the idea that Cody helped aggravate the state of California to come after Matt and the gang because Cody's a fucking snitch. That's what he does. He's a snitching motherfucker. Whether or not he's a Fed informant, we don't really know, but Cody likes to snitch, it sounds like. Anyways, Matt, was approached by Garrett. And Matt was kind of like, oh, I guess he's like, we're gonna like fist bump or something, bro. And no, Garrett spit on Matt. Like, he spit on that thing. Yeah. Hold on, come. Uh-oh. Hold on here, chat. What? So yes, they spit on the poor man that was there. So, chat. I mean, whew. The court is aware of what's happened. Are you saying it's based? Like, because he's yes. Because Matt's half black. It's like, yes, spit on minorities, make a hate crimes based. It's like, no, we don't want this one. No. This could lead to a lot of problems for Cody and his team. Whoa, buddy. Whoa, buddy. Yes, it sounded like a very unfortunate and very racist, unprovoked attack. Yep. Very true. John Crump News says sup in. Yep. Thank you. Thank you for being here. But yeah, spitting on somebody. That's what this was about. Literally, they fucking spit on that thing. That's not something you want the court to have to know about, because now the court's going to have to deal with that. Debbie says, did anybody get arrested yet? No. My understanding, police reports have been filed. The marshals have determined this is outside of our property. It's in the city of Orlando. I think stuff is being worked on, and the city or Orlando's trying to figure out what to do. But as of right now, nothing. Yes, some rational, well-behaved people on Team Cody. And Johan says, Gabe Hoffman, are you behind this? Kia Patrick says, we get it. He's black. He's not 3/5 of a person. But they're property. They're people now, not property or things. But yes. Debbie says, good Lord, how juvenile. Well, Cody and his team are a bunch of taint-munching assholes. So there you go. But yes, that is kind of where things are right now. And this is a hilarious update. I know the beginning of this is kind of boring, chat, but we got to the end. And this is pretty fucking based. This is pretty based of a story. I mean, like, look how bad it's like. This is not how you do a lawsuit, chat. John Crump says, which guy did it? Garrett, Wallyman. I don't know. Whichever one of Cody's. It's Cody's like field hand. So I don't know which one it is. It's Garrett Whaleyman or Wallyman. I don't know. He's the main ball licker for Cody Wilson, who's been handling stuff. Yeah, Wallyman or Whaleyman. I don't know. Yeah, it's Garrett. Garrett Wallyman. Yes, and that's the other thing too. Yes, who witnessed it? Matt's attorney witnessed it. Cody's attorneys witnessed it. Everybody fucking witnessed it. So now we have like 2 sets of attorneys who have now witnessed it. There will be camera evidence, not only from the courthouse, but God knows what else is around to see it. Yeah. Sweet Tooth says, can we cover the au pair sentencing? We can do that tomorrow. Yes. Tonight we are going to do a little bit more work on, I don't know what tonight we're going to, I thought we'd be able to take a break from bolt action tonight, but we got more to paint because I was digging through some of the stuff I had, and I didn't realize that as like given as an additional gift because of everything that got bought. There was like a whole nother flat of like bolt action Africa Corps dudes that I have to paint and take care of. So like I have extra people and I had to make a bunch of these bad boys. I had to make some sand on the tablets, on the pedestals. We had to make those. We had to make a couple of these bad dudes, getting them all ready to go. So yeah, we got a little more work to do. So we're going to work on that tonight. Rare Breed lost pretty bad in court today. Well, that's interesting because I heard yesterday Hoffman Tactical took a big L with the injunction. What happened with Rare Breed, if you could fill us in? So am I saying I've never spat on a man while doing gay outreach for my law firm? No. As the executive vice president for gay outreach at the Martin Law Office, no, I've never spat on another man, even if they wanted it. Oh. Judge thinks her patent might be invalid. Well, that's I need to get ready to cover that. I talked with Steven Stabuli a little bit. We might be doing a collab here coming up. But yeah, that's the bitch about patent law. A judge can look at it, like you may get a patent, you may be able to enforce it for a while, and all of a sudden a judge can look at it and go, actually, I don't think this is a valid patent. I don't think you're entitled to one. And you know what happens? Poof! It's fucking gone. Patents are insane. Like the way they work, a court can just fucking drop it. Oh, you talked to Steven tonight? Oh, okay. Well, there you go. I was talking to Steven about a little bit there. Yeah, I can talk to you. I'll reach out to you, John. I'll reach out to you. Yeah, a Rare Breed is, Runkle is correct. Yes, Rare Breed is the condom the ATF is using to fuck over the other companies. Yes, and that's part of why the DOJ did their settlement with Rare Breed a while back. Matt covered this when it happened. Rare Breed basically got a dispensation from the government saying, we're going to leave you out of their lawsuit. You remember at the time when Rare Breed got taken on by the ATF, everybody was like, rally the wagons. But then they cut a deal with the ATF. And part of that was they, go forth and sin no more. And you have to enforce your patent against everybody. So Hoffman Tactical for the super safety, they're going after everybody. Everybody for forced reset triggers, even if it's not remotely close. Like, the super safety for Hoffman Tactical is nothing at all like what Rare Breed's doing. They're going after everybody. So, I need to work on that. That's something I need to get put together. That requires a little bit of work, but I may reach out to you, John. I might reach out to you there. Oh, he's represented you a few times. Yeah, Steven's a good attorney. Very good attorney. I got to reach out to him, but I'll reach out to you too as well. So, thanks for being here. Shinobubu says, currently looking for a patent attorney. Those are worth their weight in gold, and you just got to look around in your area. You might find one that can do it. You may be able to find one who's not local, depending on what you're trying to do. He might be able to help you out anyway, but you just Google around, try to find one. But yeah, make sure you find one that's actually past the patent bar. Like you have to take a separate bar exam to go in front of the patent board. So yeah, Kurt would be a good person to help point you in the right direction. So Jordan Bemke says, if you cut deals with the ATF, you can't sit with us. That's correct. Seats taken. Can't sit here, Forrest. But also, it turned out with the Rare Breed guys, they're just fucking assholes anyway. Even without the ATF deal and the DOJ deal, they were just dickheads to start with. So, didn't change much. Patton was my kind of attorney. Funny. All right, guys. Well, that is it for us. We kept it under 2 hours. Like I said, this is a little bit light, a little bit funny. But yeah, as I said, this ended with a bang. Watch this ended with a hock tour, as it were, as the kids might say. So there we go. Let's get some of these other comments here real quick. Tech Guy Sus says, victory party at Stoney's. That's right, chat. Dabbing on them with $2.50 cans. Brad says it's Tover for EVS. Yes. Cyanide Cologne says, are we going to make a potentially criminal comic starring Clyde and Wonder Bread? Sure, we'll do that. I just need $100,000, chat, up front. J-Rock says the cording is crashing out. Yes, he is. Yes, he is. Yes, he is just crumbling. Crumbling. Johnny Osprey says Kino Casino should do an LLM and call it Chat PPP. That's awesome. I like that. Yes. Amon Redzo says, yes, Ethan Van Sciver is now the N-word. Yes, he is. Yes. Yes. Yes, maybe it's you. Who's the N-word? EVS. If you want to know the truth about it. Spoony Samurai says, Flash is greater than EVS, but still kick Flash. Oh no, we're not kicking Flash. We don't kick Flash. Like I said, there's only one person with a kill order for this channel. We only have one person that's got a kill order. If they show up, they're automatically taken out, and they're not here. Don't worry, chat. You'll know when it happens. You'll see the smoke from Canada. Kia Pat says, Melanie Mack is getting married. No, Jeremy, no! He's like Darth Vader. No! Actually, he's like Sergeant Elias in Platoon. He's like, ah! Oh no. Oh no. Oh no. Yes, his Kofefe is under attack. Jim Cox says PPP isn't allowed here. That's not who I'm talking about. We got to kick Lofty? No. No, Lofty isn't. Lofty isn't. Total L, total Jeremy death. Well, to be fair, technically D-Day, like, not that Jeremy, yes. Total quartering death. TQD, chat. So. All right, chat. With that said, we are going to wrap it up here. We're going to head over there. Like I said, we're going to paint some more guys tonight. I got into a vibe, and honestly, like, I got a little spurgy about this, but I made a bunch of pedestals and I sanded them up, and then, like, now we can put rocks and stuff on them to make it like real desert stuff, and then we can put like little pieces of grass on. Like, see, these guys have grass now. And it's like, they're like, woo, we hide the machine gun in the bushes. So that is what we're doing there. And yes, Spud Gun, I have not missed it. It's still up here. It's sitting on my screen. It's like the last tab. It's the last of the Mohicans in my tabs. Well, this is the greatest thing ever a Spud Gun found here. And we'll watch this real quick. And we'll yes, my miniatures could touch grass now. So we'll watch this real quick, and I'll set up the other stream while we're doing this. So here we go. This is Spud Gun found this and wanted us to watch it. There we go, chat. There we go. So Yes, it's better. It's better than the current Axel. Oof, that's rough. That's rough. Can you bring Clyde to the next stream? I mean, guys, Clyde did not have his designated handler for a couple of days now. Clyde has been all about 2.0, and he's like when 2.0 came back, he was like, "I don't believe it. I don't believe you're here." He was very concerned. So, I don't know. I'm gonna leave him be because he needs some time with his purse. So, but anyways, here we go. We are gonna switch over to the model stream, and yeah, once again, just because you did it does not mean you're guilty. Um, but Jesus Christ, don't fuck with discovery like these guys have done. Not Matt in the gang, but like Cody. Nobody. Nobody. So, also, don't spit on black people at the courthouse. That's not good. Well, don't spit on anybody at the courthouse, but especially people who aren't white. That is never a good strategy. Um, bring brings 2.0 to the next street. Why do you think 30 seconds away? You tell him that. You tell him that. He's literally like on her head, like. Anyways, chat, I'll see you guys.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy that Kaden yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go. Here on Sean Martin's Potentially Criminal Show.
EDW for $2. Thank you. Last super chat. Well, I don't know. Do you mean last super chat of the show or like last super chat for the channel because I'm nuked or what? I don't know. But yeah, thank you, EDW.